Hello, everyone. Welcome back to the show. Well, this is the part of the program when you guys out there, our viewers, get to join the conversation, and you certainly have a lot of questions and are very interested in today's topic. So we're going to get to your questions, but first we want to finish out our conversation on evictions because there's so much, and actually our viewers out there do have questions about evictions, but part two of the whole eviction process. Laura?
Okay. So the next step in the eviction process after the notice goes out is the landlord filing what's called a rule for possession, where they rule you into court. And that's where the landlord has to prove their case. The landlord has the duty to prove whatever they're alleging. Occasionally, just as a word to the wise, if you have a written lease, that first 5-day notice we mentioned, it can be waived. So you really want to check that out. If you have a waiver of that notice, it can make the process happen in a week or less. Typically, it takes 2 to 2.5 weeks to do an eviction if it's for cause. When you go to court, which is step 3, the judge is going to hear the evidence, and it's really, really important when you're in court, bring your evidence. I mean, you hear all these folks in court talking about, oh, well, I have that written down or I have that receipt, but if you don't have it with you, it's like it doesn't exist. It doesn't. Sometimes you make out better if you have an attorney with you, so you can always contact us if you think you might be eligible for our services. And
go to the website even if you're not. You'll get some good practical tips. And go to the show website because we're putting a lot of the helpful to-dos on the show, the Power of Attorney website.
And then the last thing I would mention, if you do not have an answer filed, like a legal pleading filed in response to the landlord's eviction, if you lose the case as a tenant, the judges typically provide 24 to 48 hours. So it's extremely quick, and a lot of folks are kind of surprised how rapidly it moves. So, you know, from start to finish, you're talking a couple of weeks.
You said an answer file? An answer file, which is?
An answer filed. It's just a written document where you're stating, this is why I shouldn't be forced to move, and you have to have it sworn under oath and notarized, and so it is a little difficult to do on your own.
Okay, yeah, and some of these cases can get to be very complicated, I would imagine, even especially when you get into the subsidized housing issue, right?
Yes.
Yeah, okay, and so security deposits. Now, Amanda, I know this is your area of specialty here, and we actually going to start with a question from one of our viewers who says, how long does a landlord have to give a former tenant her security deposit back? So take us from the beginning on these security deposits.
Okay, well, from the beginning, what we always recommend, and we're going to keep going back to this, and I know you'd mentioned it before and Laura's mentioned it, read your lease. Before you even move out, you should give notice that you're moving out, and your lease will usually define what that notice is. So you need to give proper notice or your lease is going to what we call reconduct, which is continue on.
Give an example of giving proper notice so people out there will know what that means.
Okay, you would give written notice to your landlord, I am moving out on this date, I will return the keys. And it doesn't have to, you know, same with the notice that they would leave, it doesn't have to be on any sort of formal paper or anything like that. It's just to let the landlord know that you're moving out. We also recommend, you know, clean the place. Take pictures so that you can prove that you've cleaned the place. We also recommend when people move in to take pictures to show from when you moved in to when you move out. But once you've moved out, your landlord has 30 days under Louisiana law to either return the deposit or to provide to you in writing the reasons why they're not going to do that. There's also another rule that says that you need to make a written demand for your deposit, where you write the landlord a demand letter, and I think you guys have put that up on your website.
We're going to have some form letters up there, including a moving out security deposit checklist.
This is great to have.
You'll be able to see this on our website. Practical, helpful stuff, and you obviously want to tweak it to fit your requirements. But again, I didn't want to interrupt you with your explanation.
The tenant does have a duty to provide a forwarding address. It doesn't have to be their new address. It could be a P.O. box, it could be their mother's address, just an address where the landlord can send either the deposit or the letter stating why they're going to be keeping some or all of the deposit.
I'm sorry, go ahead. Yeah.
No.
Well, I was going to say, under what's considered normal wear and tear? I mean, how often do the tenants actually get their security deposits back?
Not often.
Yeah, that's why we ended up, you know, having a whole security deposit kind of person that was doing those, because we were just seeing so many landlords that were keeping them.
Right.
Normal wear and tear would just be like the floors are a little more scuffed because you were walking on them. It's just anything through normal usage.
Right.
So, for example, if you got mad one day and punched a hole in the wall, that is that exceeds normal wear and tear.
Sure.
But if where you can see a clear path in the hallway where people walk in and out, and it's just got a little dingier, then that's normal wear and tear because you were just using the unit as it was meant to be used.
But to be clear, if you did accidentally have a hole knocked in the wall, maybe you were moving furniture and the mover, somebody punched a hole in the wall. If that hole in the wall costs $100 to repair, the landlord can only deduct $100 from the security deposit, correct?
That's correct.
In other words, they have to be reasonable.
Yes.
And I wanted to comment, and this is a good time. In general, if you have a landlord who you don't think is treating you fair and square, either while you're living in there or when you get out and you're getting and you're trying to get your deposit, number one, thank God you're out of there, because a landlord who doesn't treat you fair and square, it doesn't matter if you're able to win that little battle and make them fix that leaky toilet or fix that air conditioning problem that you can't seem to get it fixed. You want to find a new apartment anyway, because jerk landlords are going to remain jerk landlords no matter what. As far as deposits go, I've seen it so many times. They are almost always, the bad landlords are almost always going to say it was not normal wear and tear. And I'm so glad that you guys are out there helping people who really, really need that security deposit. I mean, that's a lot of money for people who are barely making ends meet in this economy.
Yeah,
so
yeah. And when it comes to deposits, what's normal here in the state of Louisiana in terms of what landlords typically ask for? They ask for a deposit of about how much, and then first month's rent, last month's rent. Tell us, what is it that people can typically expect?
What we most commonly see when someone moves in is it'd be a deposit, which would be in a first month's rent, and the deposit would usually be the same as the first month's rent. We did a survey of 100 of our clients, and you have to keep in mind our clients are all low income, and their average deposit was $1,000.
That's a lot.
That's a
for
lot.
low income.
And that's mainly post-Katrina. Before Katrina, typically our average client might have like a $500, $600 deposit, but all those low-income unsubsidized rentals are gone with the wind and the water, so you don't find $500 rents very anymore.
Sure.
And it's a really important issue, not just for our clients, but really for everybody. And the only other thing I would mention about deposits is that, we've mostly been talking about damage, but under the security deposit law, if there are other amounts that are due, the landlord can also deduct that. So if you move outgoing rent, guess what? You're not going to get your deposit back. If you move out owing for some kind of other fees, I don't know, maybe you had late fees that accumulated, or a damage fee, or a unpaid pet deposit or something like that, the landlord is going to deduct that. So it's not just damages, although that's typically where the issues arise.
Okay, well, we have so many questions from our viewers. Another question here says, can a dog barking all night in my neighbor's apartment be grounds to terminate my lease? How do you deal with this issue if there's a dog that just will not be quiet?
A neighbor's dog.
Yeah, a neighbor's dog.
Well, is it grounds for me to terminate my lease? I was like, wait a minute, why would the landlord evict you for your neighbor's dog? But it would be, in our experience, pretty rare for you to be able to get out of your lease over an occurrence like that. What we would recommend that you do, if it is the same landlord, that you're renting from, if you both have the same landlord, that you notify the landlord, and that occasionally, if it's really out of control, sometimes potentially it could become a police matter, just depending upon, if there's anything else going on too. I mean, there could be something going on there.
Yeah, and I'd weigh in on that too. I'd say if your neighbor is creating a nuisance,
that's right, then
I don't know how much you're going to pay attention to a letter from somebody who's not a lawyer, but you have the right to say that dog barking is creating a nuisance. And I think you can complain to the police that it's disturbing the peace is what's going on there. Complain to the police about that. Try and get your neighbor to quiet down the dog, or you will complain to the police. You want to get along with your neighbors, but if you can't get your sleep, that's good enough reason to tell the neighbor, quiet down that dog, or else I will complain.
Well, whether it's a barking dog or maybe it's neighbors who've moved in and they are fighting all the time. What I'm hearing from both of you, it seems over and over again that it's important to get accurate documentation. So if you do have a complaint, it's going to be important for you to have that complaint in writing so that there's a paper trail. Is that right?
Yeah, and especially if you do go to court, because that judge has most likely never been inside of your unit. So it's going to be your word and your landlord's word, and they're going to be totally, on opposite sides. So if a judge hasn't been able to come in the house and kind of see either the conditions or what's going on, they have to go by what's in front of them. And so pictures, video documentation, receipts, letters that you wrote. You always make sure to get a copy of any letter that you write. We recommend, sending certified mail so you have proof that it was actually sent.
Right.
Email, fax, something that has some sort of, timestamp and, some sort of proof that it was sent and received is really important for the judges.
Yeah. Speaking of copies, I know that you're very big on people getting a copy of their lease. Yeah, because so often I guess that doesn't happen.
That is true. And that's one of those issues that you want to try to take care of when you first rent the apartment. There's a lot going on, you're excited, and typically there's not a copy machine just sitting in the apartment or at the property when you're unless it's an apartment complex. And we usually don't run into that issue so much with apartment complexes, but with individual landlords, often the tenant won't get a copy of the lease. And you really do want to try to get that when you first meet with the landlord. And if you don't get it that first time, maybe the next. But in this day and age now that so many folks have access to the internet and emails, a landlord can quickly just send it to you that way. So you really need to try to get a copy.
And if you can't get that copy, then some red flags should start waving, right?
Yes.
We are completely out of time for the first segment. The good news, though, is that you all are going to be back because we're going to have part 2. Thank you both so much for this first segment. We've learned so much. Be sure to join us next week for part 2 on landlord-tenant issues and what the law says. In the meantime, you can visit SLLS.org to learn more about Southeast Louisiana Legal Services and to support the great work that they do there.
Thanks so much to Amanda Golob and Laura Tuggle for the great work they do in helping those who can't afford legal counsel. And be sure to join us next week for part 2 of this hot topic. Until then, if you would like to have more information about power of attorney, visit us at johnredmannpowerofattorney.com or johnredmannpoa.com and follow us on Twitter, Facebook. Thanks again, and we will see you next time. Ladies.